Great. Good afternoon, everyone, and thank you for choosing to spend your lunch break with us. Today, my colleague Louise and I will be walking you through some of the key issues surrounding the use of surveillance at the LAT. We'll begin by discussing the disclosure obligations that apply to surveillance evidence, move into some of the benefits and potential pitfalls of disclosure, and finish with a review of recent LAT decisions that have considered surveillance and its evidentiary weight. Before we get started, I'd like to take a moment to introduce myself and Louise, and to go over a couple housekeeping items. You will see my colleague Louise on the screen shortly. Louise is a senior associate here at SBA, and she has been with our firm since 2022. Her practice primarily focuses in the area of accident benefits. As for me, my name is Irene. I am a second-year associate at SBA. I started at the firm as an articling student, and my practice includes accident benefits, tort, property liability, and coverage. Louise and I both work out of SBA's Toronto office. SBA also has offices in the Kitchener, Waterloo, and London areas. And altogether, our 26 lawyers practice a variety of insurance litigation matters. Depending on time, we may be able to answer some questions at the end of our presentation today. There is a Q&A box at the bottom of your screen, so feel free to drop any questions down there. And with that out of the way, I'll pass things over to Louise to go over some of the disclosure obligations surrounding surveillance at the LAT.
Thank you. Good afternoon, everyone. I'm going to kick off our presentation with a brief discussion on the production of surveillance once a LAT application has been filed. I'll touch on the timelines for production of surveillance at the LAT, followed by knowing what you are agreeing to produce. I will discuss some of the consequences of non-disclosure, which tends to be fact-specific and varied. And I'll conclude my portion by briefly going over the use of surveillance at examinations under oath and insurer examinations. Irene will then take over with the discussion of some of the recent cases. So at the LAT, under Rule 20.4, the first obligation for production of surveillance once a LAT application has been filed is at the case conference stage. So 10 days prior to the case conference, the parties must produce their case conference summary form, which includes listing and providing all documentation that they intend to rely upon, which would include the surveillance if you're relying upon it at a hearing. So that's your first disclosure deadline, 10 days before the case conference. The tribunal can order the disclosure and production of all documents you tend to rely upon. So this would take place at the case conference. There would be an order generated following the case conference that would appear in the case conference report and order. And this is in response to the other side, the applicant's counsel, requesting surveillance. So it's important to pay careful attention to the applicant's case conference summary form. What exactly are they looking for from the insurer for surveillance and how it's worded? So we're going to discuss some of this. So I've included two examples of recent case conference summaries that I've received from applicants' counsel that have set out requests for surveillance and production of it from the insurer. So this first example, the applicant requested any surveillance if relied upon at the hearing. So this is a very generic request. It could be interpreted narrowly, limiting the disclosure to the final report and edited video. As the wording indicates, there's not a lot of detail here. They're not asking for a lot of specific information, just surveillance, which I would interpret that to be very narrow and just the report and the edited video. The second example is far more detailed. It is asking for the complete surveillance file, including raw and unedited video footage, unedited photographs, draft reports, and final reports, the investigator's CV and unedited notes, and communication between the insurer and the investigator. This is obviously a very thorough and detailed request. There's less likely opportunity for any misunderstandings as to what the applicant is requesting from you in terms of surveillance. Most of this is producible, and I don't really see any basis for opposing it. However, I would just highlight two important points. the communication between the insurer and the investigator could be subject to litigation privilege. So you may not want to agree to produce that. And also there's no disclaimer or qualifier on here that it be produced only if relied upon. So I would make sure in response to this request that at the case conference, what you're agreeing to is only if relied upon. So the key takeaway at the case conference stage is knowing what you've agreed to produce, knowing that there's a meeting of the minds as to what that entails, and how it's going to be worded in your case conference report and order. So language is important. Always make sure you've included that qualifier of if relied upon at the hearing. So at the case conference, the adjudicator will make orders for productions, and they will have a deadline for production of those documentation or documents, including the surveillance. So the first production deadline is usually 30 to 45 days after the case conference. This is the opportunity to disclose all surveillance currently in your possession that you intend to rely upon at the hearing. The second deadline is usually 60 days, could be 45 to 60 days post-case conference. This is your opportunity to produce any other documentation that you intend to rely upon at the hearing. This would include additional surveillance, surveillance that may not have existed at the time of the case conference. This is your time to go and get more surveillance. But it is a quick turnaround. Like I mentioned, usually 45 to 60 days after the case conference. So if you were contemplating additional surveillance of your applicant, the time to do so after the case conference is fairly quick. So you'll need to get on top of that. The third most important deadline for production of surveillance is in the hearing brief itself. So the surveillance is producible, surveillance that you intend to rely upon needs to be included in your hearing brief. And the hearing brief needs to be provided, served and filed 21 days prior to the hearing. There are consequences that will flow from this if you miss any of the deadlines that we've talked about. So Rule 9.3 of the LAT rules says failure to comply with any disclosure rules or orders may result in being unable to rely on the documents at the hearing. This is subject to the tribunal's discretion. It would usually be done by way of motion, even perhaps at the start of the hearing or before, whether or not the insurer is able to rely upon surveillance that it failed to disclose within the production deadlines ordered. So we have some case law for some guidance here, and we'll be discussing a little bit of that. Before we get to those decisions, the tribunal, in making its order, will consider these factors that I've listed here on whether or not surveillance that was late disclosed is can be relied upon at the hearing. So they will look at the reason for the non-compliance, the prejudice to either party in not being able to rely upon it or having it be entered into evidence, and the ability to mitigate that prejudice by way of another order or remedy. They'll also look at the extent to which the substance of the information lies within the knowledge of the other party, whether or not it's an opposed motion, and as well, they'll look at relevance to an issue in dispute. So the relevance of the surveillance to an issue in dispute. There is an issue about surveillance done prior to the LAT application and whether or not that's producible. Litigation privilege also arises in the context of if you have surveillance that perhaps you don't wish to disclose, can you make a claim for litigation privilege to avoid having to disclose that surveillance? So the test for litigation privilege is, was there a reasonable prospect of litigation at the time the document was created? And is the dominant purpose of the creation of was the dominant purpose of the creation of the document to assist in the contemplated litigation? So that's the test that the tribunal will look at and whether or not they will apply litigation privilege. Generally speaking, litigation privilege arises from the filing of the LAT application, and surveillance conducted prior to the LAT application may not be protected by litigation privilege. We have some case law on this. The decision of RD and Wawanisa in 2019 ruled that surveillance prior to the LAT application must be disclosed. The insurer must advise of the existence of such surveillance, the date, time, place, and reason for their surveillance, and provide a copy to the applicant, regardless of whether the insurer intends to rely upon it or not. After the LAT application or after litigation privilege arises, the decision of Nurzan, Najdabeen, and Economical said the insurer is not required to disclose the existence or particulars of surveillance obtained after litigation privilege arises unless it intends to rely on surveillance at a hearing. So this creates 2 points in time. The date from which your litigation privilege arises, most likely your LAT application, depending on what else has been happening in the file to date. So surveillance prior to the LAT application, according to the RD and Wawanesa case, would be producible even if you're not intending to rely upon it. Surveillance after the LAT application is not producible unless you intend to rely upon it. But as I'm just going to discuss in the next slide, there's been some good changes there. So generally speaking, in more recent practice, adjudicators are limiting surveillance requests to only if relied upon. They're not making the distinction of prior to the LAT application date or considering litigation privilege arguments. They're generally just saying surveillance is producible if relied upon, but it's something to consider back to when we were talking about how to word the request for the surveillance production in the case conference report. So just pay attention to that at a case conference, and always if relied upon is your best rule of thumb. Okay, so I just have a couple comments here of some takeaways from some decisions of the LAT that have discussed surveillance and how they've interpreted or the use of it. So in Hanabarco and Intact 2023 decision, the adjudicator said surveillance does not provide any context as to how the applicant was feeling that day or the day after. This is a pretty common response that we hear from applicants' counsels when we disclose or produce surveillance that is only a snapshot in time. It doesn't provide the complete picture of function in the days before and days after. So this is a notable decision, as the adjudicator was very persuaded by that line of thinking and included it in their decision. Now we're getting into a few cases that would discuss the consequences of late disclosure of surveillance. So in Cower and Northbridge, another 2023 decision, surveillance was disclosed by the insurer to the applicant's counsel 90 days prior to the hearing as part of settlement discussions. Unfortunately, the insurer did not include the surveillance in their hearing brief, which was filed 21 or 10 days prior to the hearing, depending on the rules that were in place at that time. Due to inadvertence, that was missed from the hearing brief. And on day one of the hearing, the insurer provided a supplementary brief, which included the surveillance. Again, this was surveillance that had already been disclosed to the applicant 90 days earlier. But unfortunately, the adjudicator ruled that the surveillance was inadmissible and was excluded from the hearing. According to the adjudicator, disclosure for settlement purposes was not the same as disclosure for the purposes of preparing for a hearing, and that allowing surveillance at such a late stage would prejudice the applicant. And I feel that I've repeated this a couple times already, but they had this surveillance 90 days before the hearing. That was, in my view, there's sufficient time to prepare the applicant, but the surveillance was excluded. So just a reminder from this case of the importance of adhering to the disclosure deadlines. But it's also fact specific, and it can be, I think, perhaps adjudicator specific. In this case of Siva Ramesh and TD Insurance, which was also from 2023, in this case, there were 3 rounds of surveillance. The first 2 rounds were disclosed to the other side as part of the production deadlines. All of the deadlines were met. The third round of surveillance, unfortunately, was missed. So it was not disclosed until it was included in the hearing brief, 21 or 10 days prior to the hearing, depending on the rule that was in place at that time. The reason that it was missed in the earlier disclosure deadlines was inadvertence. The insurer corrected the inadvertence once it became known in preparing the brief, and the hearing or the surveillance was disclosed at that time. The tribunal allowed the surveillance in and said the applicant had the opportunity to address the surveillance at the hearing. So depending on the rules that were in place at this time, the applicant received the third round of surveillance either 10 or 21 days before the hearing, and that was considered sufficient enough time, and the surveillance was allowed in. This is a 2022 decision of Heather Hillier and Aviva, and this is a caution that inadvertence might not save you. In this case, the surveillance was not disclosed as any of the earlier production deadlines and was only included on the eve of the hearing, I believe. At this point, the adjudicator ruled that it's not the applicant's responsibility to correct the inadvertence of the insurer, and the applicant cannot respond to evidence which is not aware of. So we have obviously conflicting decisions here, and as I mentioned, it's very fact specific that will drive how to correct the late production of surveillance. The case of Durenzis and Gore Mutual, I've included in the presentation here because I think it's factually interesting. It's regarding a special award. So it's a claim for a special award stemming from some of the conduct from the investigator during rounds of surveillance. It's notable that during surveillance of the applicant, the investigator was apparently involved in a hit and run with the applicant's son-in-law, who was a pedestrian, and the son-in-law sustained a broken leg during the surveillance that was being conducted on the insurer's behalf. The applicant's counsel sought a special award as a result of this incident. But the tribunal held that whether the investigator was negligent and what role the respondent had in that negligence had no relationship to the unreasonable withholding of benefits. So this is somewhat unique. It's not an attempt to exclude surveillance or not have it or not allow the insurer to rely upon it. It's that they sought a special award as a result of conduct that occurred during the surveillance that was being performed with the applicant. But that obviously did not go to the test for special award, so that was not allowed. I've included Dulapia and Aviva, another 2023 decision, just of note as how surveillance is used or interpreted at the tribunal during a written hearing, rather than a video conference hearing. So in this case, the adjudicator found that the applicant was not prejudiced by surveillance in a written hearing format, that the applicant was aware that credibility was an issue. If I recall correctly, the facts of this case included attendant care invoices and the veracity of those and the credibility of the providers. So that was part of the issue. So the applicant was aware that credibility was an issue at the hearing, and the applicant had the ability and the right to reply submissions to respond to the surveillance evidence that was being included in the insurer's written submissions. And if there was an issue, they had prior knowledge that credibility was a factor. They could have requested an affidavit or affidavit evidence when they were setting the format of the hearing at the case conference, or made the arguments that affidavit evidence be included, or they could have requested a video hearing, either at the case conference or made a motion for a video hearing conversion. So none of those things happened and the evidence was allowed. Just briefly touching upon examinations under oath and surveillance, whether or not the insurer has any obligation or reason to produce, not reason, but any obligation to produce surveillance prior to an examination under oath. And the answer to that is no. There is no requirement in the SABs that surveillance be disclosed prior to an examination under oath. This decision involving Coachman from 2019 said that the tort rules of civil procedure do not apply in the SAB setting. And touching on surveillance and insurer examinations, which Irene will also discuss, if you have surveillance and you have good surveillance, you should consider providing it to the insurer's examination assessors in advance of the examination. An original report considering surveillance in the context of the examination is preferable to a subsequent addendum. But be mindful that there's no obligation to inform the applicant prior to the examination of that surveillance. And Irene will discuss that a little bit further. But at the examination, the colleges of the occupational therapists and psychologists suggest to their individuals or their members of their profession that they review the surveillance with the applicant. So that will take place during the examination. So that's something to keep in mind. It's not that controversial. It's good practice, but I think the key takeaway here that I would just want to make sure you're aware of, if you have good surveillance that you think assists you, and you have it before your insurer examinations, you should consider providing that to the assessors in advance of the examination. But you don't have any obligation to provide it to the claimant for that assessment. So now I think that's it for my portion. So I'm going to turn it over to Irene to discuss some important tribunal decisions around the use and weight of surveillance evidence.
Great. Thanks, Louise. Okay, so now that we've covered some of the general rules and principles surrounding disclosure of surveillance, I'll now briefly take us through some of the more recent decisions from the LAT. So first up, we have Paciente and Allstate. This decision was released in 2024. Here, the insurer alleged that the applicant had misrepresented his functional abilities in employment while collecting IRBs. So they relied heavily on surveillance evidence showing him driving, visiting his office building, and using the gym treadmill at his office building. In addition to the surveillance footage, the insurer had also relied on some business tax forms signed by the applicant as additional evidence that he had been working while receiving IRBs. So the tribunal ultimately found that the footage was insufficient to support the insurer's argument and that the applicant had misrepresented his insufficient to support the insurer's argument that the applicant had misrepresented his functional abilities. While the surveillance footage would appear to be potentially damaging to the applicant, especially considering the fact that he was seen attending his workplace, it was found that nothing in the video actually showed the applicant working or engaging in business activities. The tribunal found that the surveillance merely showed general mobility and didn't go as far as to prove he was actually working or had intentionally misrepresented his abilities. Given these observations, the LAT had assigned minimal weight to the surveillance and placed more weight on the income tax reports the applicant submitted, which showed he stopped working after the accident. However, despite these findings, the LAT did order a partial repayment of IRBs based on the applicant's failure to disclose payments received from his long-term disability provider. The next case we'll look at is Aviva and Subramanian. This is another 2024 decision, which sits on the other end of the spectrum. Here, it was the insurer that brought a LAT application for repayment of IRBs. The insurer had discontinued IRB payments and alleged that the claimant had fraudulently obtained benefits by intentionally misrepresenting his functional abilities. The insurer relied heavily on surveillance captured after the IRBs were discontinued, which showed him performing manual labor, including lifting, hauling, and using hand carts. The tribunal found that there was willful misrepresentation and ordered a full repayment of over $48,000 in IRBs. Here, the surveillance evidence was decisive as it clearly showed ongoing employment. Importantly, the LAT noted that the claimant had failed to comply with multiple tribunal orders, which required him to produce employment and tax records. The insurer had actually followed up repeatedly, even sending an investigator to the applicant's home or the claimant's home to obtain his signature for authorizations. But despite all these efforts, he still refused to cooperate. As a result, the LAT drew an adverse inference that the missing records would have been damaging to his position. The surveillance, combined with the refusal to produce evidence, led the tribunal to find he had been working while receiving IRBs. The surveillance here, again, was decisive and showed sustained work-like activity that directly contradicted his reported disability. So moving on to some 2025 cases, the case in Badawi and Aviva is a great example of late served surveillance being admitted. the insurer had disclosed surveillance about 4.5 months after the case conference report and ordered deadline, and the applicant moved to exclude it, arguing procedural unfairness. So the tribunal ultimately disagreed with the applicant and held that the case conference ordered deadlines were not rigid, and under Rule 9.3 and Section 15 of the Statutory Powers and Procedures Act, the key considerations in terms of admitting the evidence were fairness and prejudice rather than strict compliance. Here, the applicant still had 34 days to review and respond to the footage before the submissions were due. The LAT found that that time was sufficient and admitted the surveillance, and also found that the footage itself showed the applicant performing delivery type work, including loading boxes, pushing trolleys, carrying packages, and all of this was inconsistent with his reported physical limitations. The tribunal gave the surveillance significant weight, finding it reliable, probative, and directly contradictory to the medical evidence submitted. It dismissed both the IRB and treatment plan claims of the applicant. And our next decision is another 2025 decision in Dawood and Certus Direct. Here, the insurer relied heavily on surveillance obtained in 2020, which was about 2 years after the accident occurred, and submitted 5 years after the surveillance was obtained. The surveillance showed the applicant driving a transport truck and performing physically demanding tasks. The LAT ultimately admitted the footage under Section 15 of the SPPA. However, it placed minimal weight on the surveillance, noting that even the insurer's own assessors had concluded that the applicant had real impairments, even after reviewing the surveillance footage. The tribunal highlighted that timing and context matter, and that the old footage of 5 years and the brief observations within the footage didn't necessarily reflect the current capacity of the applicant. So the key takeaway here is that surveillance will hold the most weight if it is recent, contextual, and clearly linked to the benefit period. And our final decision here is Vasos and Heartland Farm Mutual. This is actually an earlier decision released in 2022. But I thought it'd be interesting to include because it deals with a very important issue of surveillance disclosure in the context of insurers' examinations. Louise has previously touched on this, but I thought this decision was a great illustration and a good application of the rules. So in this case, the insurer had conducted surveillance of the applicant, which was sent to the Section 44 assessor in advance of the examination. During the examination, the assessor showed the applicant the surveillance footage. However, the existence of the surveillance was not previously disclosed to the applicant or his counsel before the examination. The applicant later brought a motion to exclude the surveillance and any Section 44 reports that relied on it. The applicant argued that the insurer's conduct was procedurally unfair and a breach of the duty of good faith. He said the video was effectively sprung on him and he had not had a fair opportunity to review or respond to it. At the hearing, the tribunal dismissed the motion. The LAT held that there was no provision in the SABs that expressly required the disclosure of surveillance before an insurer's examination. And in admitting the surveillance, the LAT specifically referenced Section 15 of the SPPA, which allows the LAT to admit any relevant evidence. It was further clarified that the tort rules of civil procedure surrounding pre-discovery disclosure did not apply to LAT proceedings. Overall, the decision in Vasos that stands for the proposition that advanced disclosure of surveillance prior to a Section 44 examination is not required. However, it is important to note that the LAT expressly stated that while the surveillance and resulting IE reports were admissible, the weight given to the evidence could be challenged at a hearing. So unfortunately, it looks like we don't have any time to answer questions today, but if you think of any questions later, or if you've dropped any questions in the Q&A box below, we'll be happy to answer any of them via email. So please feel free to reach out to Louise and I. Similarly, if you would like a copy of today's PowerPoint presentation, we are more than happy to send a copy if you just reach out via email as well. This webinar has been recorded and will be uploaded to our website next week if you want to return to it later or forward it to a colleague. But thanks for joining us today, and I hope you guys all enjoy the rest of your days.